Again, welcome to Law and Life. This is a second episode on Article 142, an assessment and critique. If you haven't watched the first video, you can visit the link given in the description box. And I am Vishakha as a host with the Senior Advocate of India, Subodh Markandeji. Starting this episode with my first question. Kindly tell us, our viewer, the later decision of Supreme Court that let down the counter on Article 142.
So I have selected some cases out of a large number of uh, cases on this subject. So let's examine first the cases which define the contours of Article 142 and later on some select cases which, to my mind, adds value addition to Article 142. So on the first aspect, there was a very shocking case of Delhi Judicial Service versus State of Gujarat. What happened there was that the Chief Judicial Magistrate in Navsari, a town in Gujarat, was beaten up, arrested, handcuffed, and paraded in the street for having complained to the higher police authorities against police personnel for neglecting to serve the court summons and notices. So naturally, it created widespread outrage throughout the country, particularly amongst the district judiciary and the bar. So the Supreme Court, so this Delhi Judicial Service, filed a PIL in the Supreme Court against the state of Gujarat, and after ascertaining the facts through a commission appointed by the Supreme Court, and after issuing contempt notices to the erring police personnel, the Supreme Court delivered its verdict. It held that expression cause or matter includes almost any proceeding pending in the court and will certainly include power to quash pending criminal proceedings. To the same effect is the ratio in that very infamous case of Union Carbide versus Union of India, the Bhopal gas tragedy case, in which Supreme Court further laid down that any limited interpretation given to Article 142 will stultify the wide constitutional powers. This plenary power cannot be curtailed by any statutory provision. So the next case in the series is Pandit Chetram versus Municipal Corporation of Delhi. Uh, I don't know whether to give the citation, 1995, 1 SCC 47. In that case, the court held that Article 142 enables the Supreme Court to do complete justice. That is to say, where it is required to remand the case for rehearing according to law or make further orders where the judgment of the High Court was otherwise liable to be set aside. Article 142 also empowers the Supreme Court to do complete justice. In this case, to extend the benefit of the judgment passed by the Supreme Court earlier to a case not in appeal where interest of justice so requires. So just see the wide power. The case is not before the Supreme Court, but giving, it is extending the benefit of an earlier judgment to the present case. So this is laid down in State of UP versus Poshu, Yaya 1976 SC 1750. Similarly, this article enables the Supreme Court to override any interim order obtained from the lower court, which could defeat the decree passed by the apex court. So this is laid down in Roshan versus Sriram Cotton Mills, Yaya 1990 SC 1881. Now it has been laid down in Arjun versus Jamnadas 1989 4 SCC 612 that Supreme Court cannot do anything to do justice to one party which affects the substantive rights of another party. That is, you you can't do anything to do justice to one party which affects the substantive rights, and all the more so fundamental rights. This has been laid down in the case of Chief Minister of Maharashtra, A.R. Antule. So the case is A.R. Antule versus R.S. Nayak, 1988 to SCC 602. So these are the cases which lay down the contours of Article 142. So here also I have selected five say, cases because there are a very large number of cases and it's not uh, possible having regard to our format, which is limited. So I have selected one first. The first such case is B. Prabhakar Rao versus State of Andhra Pradesh, Yaya 1986 SC 210. In this case, what happened that one bad morning, the state government of Andhra Pradesh suddenly reduced the age of superannuation of more than 37,000 government servants, employees of public sector units, public corporations, and Tirupati Tirumalai Devasthanams from 58 years to 55 years. So suddenly a person who never anticipated that he will be retired one fine or bad morning, he finds that he is retired. Now, naturally, this was challenged before the High Court of Andhra Pradesh and the Supreme Court also. But this was through an executive order, and the first round of litigation failed before the Supreme Court. But what happened that the state itself felt a lot of difficulty that suddenly so many employees have been retired. So realizing its own grave mistake, the state government started negotiations with the employees' representatives, and the negotiations yielded this result that the status quo ante in respect of all the employees will be restored. But in the ordinance which was issued, which was followed by an act of state legislature, the present employees who were really aggrieved of this action were excluded. So this was, something like, stab in the back of the employees. This gave rise to second round of employees in which the Supreme Court uh, held in favor of the employees and gave a series of directions anticipating that the state government may again, do something mischievous. Therefore, to thwart any such move on the part of state government, the Supreme Court itself gave a series of directions so that the state government may not defeat the order or decree which the Supreme Court would pass in that case. The second case, to my mind, is Vishakha versus State of Rajasthan, AIR 1997 SC 3011. This exposed the vulnerability of women at their working place. To prevent further danger and hazard to which the working women were exposed, more so in the absence of any legislation by either the parliament or state legislatures, the Supreme Court itself gave a series of directions under Article 142 for ensuring the safety of women and protecting their fundamental rights guaranteed by Articles 14, 15, 19, 1G, and 21. It further directed, this is very important, that till proper legislation is put in place, the directions of the Supreme Court will remain in force. The third case, which I would like to cite, is Vinit Narayan versus Union of India, 1998 1 SCC 226. Here, the Supreme Court, with the help of Article 142, tried to ensure probity in public life, besides revamping the top appointments in the Central Vigilance Commission and the Central Bureau of Intelligence. There is one more case which I would like to bring to the notice of our viewers is State of Haryana versus State of Punjab, 2004 Supplement 2 SCR 849. Here what had happened that State of Haryana was allocated some water from Satluj and Bias rivers. But in spite of decree passed by the Supreme Court, the decree was not being obeyed by the State of Punjab. So another round of suits followed. In the latter suit, the Supreme Court directed the state of Punjab to construct the canal within its territory for delivery of waters from Satluj and Bias rivers, to which the state of Haryana was held entitled to. Keeping in view the long prevarication by the state of Punjab, the Supreme Court gave a series of directions under Article 142 to the Union of India and the state of Punjab for quick and orderly execution of the Supreme Court decree. Lastly, I would like to say something about the famous Shri Ramjan Bhumi temple case. There, the Supreme Court gave directions under Article 142 of the Constitution to the Union of India and the state of Uttar Pradesh to give to the UP Sunni Muslim Waqf Board land to the extent of 5 acres for construction of a mosque, in spite of the fact that UP Sunni Muslim Waqf Board had lost the case. But in spite of the loss, the Supreme Court directed under Article 142 the grant of 5 acres of land for construction of mosque. So these are the contours and these are the value addition to the to Article 142. But as I said earlier, in the earlier episode, the question is not passing on a decree or you may pass a very detailed decree and still, it is defeated. As I pointed out there, the Union of India has not uh, passed any law as envisaged by clauses 1 and 2 of Article 142, laying down the mechanism for enforcement of the orders and decrees of the Supreme Court. And that is causing enormous difficulties for the common litigant, and it's a great challenge. The order passed by the president, called CO number 47, is vague and extremely unsatisfactory. It actually provides nothing. So these challenges must be faced.
Yes, sir. This will cover all the essential and the important
And
cases in the.
obviously, that till such time as the parliament passes a law in that behalf, Supreme Court itself, in exercise of its power under Article 145 to make rules for practice and procedure before the Supreme Court, read with Article 142, should give directions in the same nature as it did in Vishakha's case, which should remain operative till the law is passed.
Yes, sir. And so this will cover all the essential and the important cases of Article 142. And thank you for sharing your knowledge on related to Article 142, sir.
Thank you very
And
much.